Welcome, everyone. Looks like there's one brave soul that's got his camera on. As you may or may not know, my name is Glenn. I'm an attorney with Woods and Bates. Going to talk about some estate planning basics today. I have everyone muted for the time being. I will probably unmute everyone once we get through the presentation here. Should run 20, 30 minutes of information and then give you some time to ask some questions if you want to. I have Kate Andrews from our office is on the call here, and looks like Michael Fleshman is too. If you have questions as we go, why don't you go ahead and scribble those down, or if you want to, you can send a chat message to Kate or send a chat message to the group, and we'll work on those questions when we get done here. Starting here is just my contact information. I'll put this up again at the end, but I want to talk with you a little bit about estate planning and some of the basics, some of the basic documents we use when we're doing estate planning. So the first, I think we should probably start with a definition. What is my estate? When we talk about someone's estate, what we're talking about is everything that person owns, whether it be real estate, personal property, anything that they have. That's what we refer to as the estate. Okay, so when they die, they're going to own assets. And what we're doing when we're doing estate planning is we're planning for someone's ultimate death. We're going to try to ensure that the assets pass to the appropriate person or the entities they want with the least amount of tax implications. Okay, are we leaving our assets to specific people, charities, organizations, whatever we want? And can we do that without having to pay any tax on what we worked hard to earn during our lifetimes? Just a little outline of what I want to talk about today. So first, I want to talk about a last will and testament. We call that a will versus a revocable living trust. What's the difference in those? What are they? What's the difference between a will-based plan and a trust-based plan? What are the pros and cons of those? Next, I want to talk about what are we thinking about? What are we talking about when we are doing estate planning? What information do we need to begin the process? What do we need to talk with clients competently about what we need to do? Then I want to get into a little bit of lifetime giving. Are you allowed to give away your assets while you're living? Answer to that is yes, not to spoil my presentation too much. But then I want to finally talk about powers of attorney a little bit, what those documents are, why we think they're important, and what those do. So that's a roadmap for what we're going to do today. All right. So let's start with last will and testament, or a will. What a last will and testament is a document that directs what's going to happen to somebody's estate when they die. Okay. So where do I want my assets to go? That document, once somebody passes away, is going to be probated. That's the process that we use in the court system in Illinois to give effect to the will document. So that probate process is going to be started probably by the nominated executor. So that will nominate an executor, and that would be the person that the decedent has nominated to wind up the affairs of the deceased. The will, in addition to nominating an executor, is also going to it can do a lot of things, but one of the important things it can do is it can nominate guardians of minor children. If you have minor children, we can make those nominations within the will document itself. So that is will-based planning. And when we talk about trusts, the type of trust I want to talk about today is what's known as a revocable living trust. Okay, there is all kinds of trusts. If we wanted to talk about a list of types of trusts, I could give you probably 10 or 15 of them. There's trusts, there's trust created in the will, testamentary trusts, there's special needs trusts, there's all kinds of different trusts. The ones we're going to talk about today, the most common, I would say, are revocable living trusts. These are trusts that people create during their lifetime. When these types of trusts are created, they will do several things. We will basically be creating a new entity, is the best way to think of it. And what we're going to do is we're going to retitle the assets that the person creating the trust owns individually into the name of that trust moving forward, so that the trust then owns those assets. The trust document is going to appoint a trustee. That trustee Most of the time is a person that's creating the trust. It doesn't have to be, but then we're going to also nominate some successors to that person. So if that particular trustee can't act, there's people that can step in and do the management of the trust assets. Having a trust-based plan does not negate the need for a last will and testament. Even if you have a trust and we've retitled all the assets in the name of the trust, there's still going to be a will there. We call that a pour over will. And what that will says in essence is I leave everything I own to my trust. And we do this for kind of a safeguard in case things change and we don't get something named in the name of the trust and it's in the name of the person that died. It will eventually get it to the trust, and the trust will say, here's where I want my assets to go, so that there's not something left out there in limbo. If we do this type of planning correctly, this type of planning can avoid probate, like we talked about earlier, which is the court process we use for giving effect to wills. There's pros and cons to both will-based plans and trust-based plans. I'm going to go over those in just a second, but I want to give you one more definition before we do that. If somebody passes away and they do not have a will, that person is known to be, so the laws of intestacy then in the state of Illinois dictate what happens to the assets of that person that passed away. And they say, okay, in default of a will, here's where your assets are going to go. Going to go to your spouse, or they're going to go to your spouse and your kids, or from there it gets a little bit more complicated. But that default is not necessarily what most people would want to have happen to their things when they're gone. Having a will avoids that instance of intestacy. Here's a little chart that I put together, and this kind of goes over some of the pros and the cons, if you will, of will-based planning versus trust-based planning. So on the left is will-based planning, and on the right, we've got living trust-based planning. So this first section here talks about while you're living. Will-based planning while you're living has a little bit lower upfront costs to create. And the reason for that is the next column there, it has a little bit lower time commitment. So in a will-based plan, what you're saying is I'm nominating this executor to do these things when I'm gone. So you're kicking that can to after you're deceased. So obviously there's not a lot of time commitment to do that. It does not delegate control of assets during your lifetime. So you continue to maintain ownership of everything that you own. You continue to be the one that controls those things until you pass, and then your estate, your executor would be the one that controls those assets. Differentiating that from a will to a trust, while we're living, the trust costs a little bit more to create. And the reason for that is there's a little bit more time commitment, a little bit more work involved to ensure that trust is adequately funded. Like we said, we're going to convert assets from individual ownership to the name of the trust. And that's going to take some work. With real estate, for instance, there's going to be a deed that's recorded from the individual to the trust, and that's going to convey the ownership of that asset. Bank account, you're going to have to go to the bank and change the ownership from the individual to the trust. So there's some more work that needs to be done there. One of the pros, if you will, of this type of planning is that a trustee is going to have control of those assets. So there is some control of assets. If somebody that created that trust did become disabled, that their successor trustee would have automatic control of those things. So that's while we're living. After we're dead, then in a will-based plan, as we discussed a minute ago, there is court involvement. So the initiation of the court process is what starts that probate process. So the court is involved in that. That will gets admitted to probate. And once that executor is appointed by the court, the judge is going to enter some orders making that happen. They're the ones that are going to transfer assets to the beneficiaries. So their marching instructions are included in that will. And that executor is going to know what that will says and know what they're supposed to do. So they're going to gather the assets. They're charged with protecting them. They are there to pay any debts and then ultimately distribute those assets according to the terms of the will. Cost of this is a little bit higher. Again, there's more work. There's more requirements that have to be met there after somebody passes away with a will-based plan versus a trust-based plan. It's more time consuming. Rule of thumb, our goal is to hopefully get estate administration matters, probate matters wrapped up within the first calendar year, within a year from when we start to when we finish. That doesn't always happen. There's reasons for that, but there is some time that it takes to do those things. There can be some delay in getting authority for the executor to act in a will-based plan. If the executor is not yet appointed by the court, they haven't been vested with authority, they can't get to those assets sometimes. So that delay can cause some problems. A delay where we live in central Illinois is not, a week, maybe 2 here. But if you get into counties like Cook County, for instance, there's a lot of delay there, as you can imagine. Based planning, there's not a lot of privacy. Probate records are public. Anybody that wanted to go look at those records, they could see them. So if we have a trust-based plan, after the person passes away, there is no court involvement in trusts in the state of Illinois unless there is litigation of some sort. We've got beneficiaries arguing or something like that, which hopefully avoid that with some clarity and some discussions with those people. We have a document that appoints a successor trustee that steps in. They don't have to be appointed by the court. They're automatically vested with authority to act. They can use that document to do what they need to do. Our hope is, if we've done everything appropriately, that there's minimal cost. I say that the trust is properly funded. If we've transferred all of our assets from the individual to the trust is properly funded, we hope there's minimal cost. We hope there's minimal time commitment. We hope there's no delay, that all happens pretty quickly and that the trustee is able to pay debts and distribute assets without a lot of headache. One of the pros on this side of the chart here at the bottom is that there's total privacy with trusts. So those that are going to be involved in a trust administration are normally the trustee and the beneficiaries. That's about it. You're not going to have a court involved or a judge involved or heirs at law or anything like that. There's some pros and some cons to both. When we talk about either a will-based plan or a trust-based plan, ownership of assets and beneficiary designations become really important. Okay. So this is one of the things that we talk to people about a lot is how do you own your assets and do you own them with other people? Do you list beneficiaries on those accounts? Those types of things. Ownership, there's different ways that you can own things. For instance, real estate is a real good example. If you own something jointly with someone else and you have rights of survivorship on that ownership, when one or the other of the joint owners passes away, the surviving owner is automatically going to own that asset outright by operation of law. It doesn't matter what your will says. It doesn't matter what your trust says. It doesn't matter what any of those things say. If you own something jointly with someone else, that's what's going to control. Same thing with beneficiary designations, transfer on death, payable on death. Any of those designations are going to control what happens to those accounts. As an example, I have a life insurance policy. If my life insurance policy says I'm going to name my sibling as the beneficiary, but I have a will that says I leave everything I own to my wife, when I die, that life insurance company is going to contact the beneficiary of the policy. They're going to get some information from them and they're going to write a check for the death benefit of that policy. They don't care what my will says. They don't care what my trust says. So those things are really important. One of the things we do from the outset is we ask people to provide us with that information and inventory those things just to make sure that what we're doing is in line with their goals, with their hopes for where things are going to go. What we don't want to have is we don't want to have something that doesn't align with the plan that we put in place, because then we've wasted our time. What we call that is asset alignment. We're aligning the assets, the ownership, beneficiaries, et cetera, with the estate plan. So if we have a desire to have our spouse own everything we own when we die, we want to make sure that our spouse is a beneficiary or our beneficiary is our estate or something along those lines so that it goes where we want it to go. This is important also if things change. So we say a lot of times that these are not static documents. These are not set it and forget it type things. We need to be looking at these all the time. So if our life circumstances change, the biggies off the top of my head would be death, of a beneficiary or a loved one, divorce, birth, disability, those types of things. Those may change what the plan is. Those may change how we need to own assets or how we need to list beneficiaries, those types of things. So it's important to look at them. I think a good rule of thumb is probably annually to take a look at it and change as necessary because things do change. One of the, oh no, gotta go back. One of the things we look at when we're talking about estate planning is taxes. We have now a unified tax system where there is a estate tax that's assessed on certain estates that are above a certain value. And when we talk about the estate tax, what we're talking about is the gross taxable estate. So when we calculate someone's gross taxable estate, we are calculating the value of everything that they own at the time that they died. So this chart breaks that down, I hope, a little bit better. When we're talking about things that are owned, we differentiate between probate assets and non-probate assets. So probate assets are going to be assets that the deceased individual owned just in their name. Okay. There's no other joint owner. There's no other beneficiary. It's going to be distributed according to their will or according to the probate process. Like we talked about earlier, their will is going to say, here's my beneficiaries. That's who's going to ultimately receive probate assets. If they don't have a will, again, they're what's called intestate. Their heirs at law would eventually inherit. That is differentiated from what we call non-probate assets. That would include things that have joint ownership. The surviving joint owner is going to own those things. Things that have beneficiaries, transfer on death, payable on death designations. Those beneficiaries are the ones that are going to inherit trust. If the trust owns assets, those trust beneficiaries that are listed are ultimately going to inherit those assets. So the gross taxable estate takes into account all of these things. If we have a piece of real estate that somebody owns jointly with someone else and they die, half of that value is going to be what's included in the gross taxable estate. We have a life insurance policy that we talked about. The value of that policy is going to be includable in the estate. So that's how we calculate this amount. When we get to the total, in Illinois, if the total of those assets is above $4 million, there is an estate tax that's assessed and has to be calculated. The estate tax return has to be filed. That exemption in the Illinois system is different from the federal exemption. The federal exemption is approximately 13.6 million. So it's much higher. And if the estate is worth more than that, then there's a tax that's assessed. If it's less than that, it's exempt. Okay. So those amounts change. That's what they are today, as I sit here, but they're worth keeping an eye on because those are what we use to determine whether or not we need to limit estate tax. Okay. So that compiling of the list of assets, noting the ownership, all that's important to figure out. Do we have estate taxes that we need to plan for, try to avoid, or do we not? Then we go on, we talk about what are our goals to get these assets distributed after I'm gone? Who do I want to be my beneficiaries? Where do I want them to go? Do I have charities that I like, that I want things to go to? Are there organizations that I'm involved in that I want to get some of these things? We also want to talk about the beneficiaries that I am going to list. Do I need to protect them in some way from themselves? The best example of that is minor children. Do I want to have minor children come to own assets at age 18, or do I want somebody to hold those longer? Do I need to protect them from themselves? Do I have beneficiaries that I know are spendthrifts? Do I have beneficiaries that I know are disabled? All those things we want to think about. We want to make sure that we're providing for those too. And then finally, one of the things that we discuss is who do I want to act as the executor or the trustee or the agent, things like that. Who's going to fill these roles? It's our position that it's a good practice to nominate not only somebody to do those things, but to nominate somebody to do those things if the person we've nominated first can't. So we like to nominate at least one successor for all those positions to make sure those positions can be filled. Okay. As we continue these discussions, we talk about if there are minor children, who do I want to care for those minor children if their parents aren't around anymore? Biological parents are the default guardians of children. And we would be talking about if those biological parents weren't able to care for the kids anymore, who's going to take that on? That there's a differentiation in Illinois. There's two different types of guardians. There's a guardian of the estate, which is the person that deals with the money, who's going to handle the money that the kids had or come to own if they're minors. And then there's guardian of the person. That's going to be the individual or individuals that takes them to school, gets them to the doctor, hounds them to brush their teeth, get in a shower, or do all the things that kids hate to do. So that is an important discussion. And then I touched on this a little bit earlier. Should I create a trust for my minor children? A guardian can hold the assets up to age 21 if it's in writing, specifically in referencing the statute that provides for that. If you want somebody to handle those monies beyond age 21, it would need to be in a trust, and the trustee would be the one to do that. That can go on for many years, a few years, how we're paying that out, how we're paying the income. Those are all things that are going to be in the trust document if that's something that we think is important. And then, do I want to make any specific requests of property? That's got to be outlined in there with enough specificity to know these are the things that I'm giving to these people. I want my gun collection to go to my grandson. Okay, we're going to want to put in there, I want my Browning, whatever it is, with enough specificity to know that those items are to go to those people. Just briefly, when we are alive, I get a question a lot, can I give this away? Sure, you can give it away. Give away everything you own to anyone at any time. But that's not to say that there may not be some unintended consequences with that. So there's some numbers we look at when we're making gifts to make sure that we don't have these unintended consequences. Any individual can give any other individual within any calendar year an amount that doesn't exceed $18,000. They don't have to file a gift tax return. Okay, the IRS says if the gift's over $18,000, you have to file a gift tax return. That's important for our discussion because if you file a gift tax return, the amount of the value of that gift comes back into the estate when you're calculating the gross estate tax or gross estate for estate tax purposes. And that can be important if we're trying to divest ourselves of ownership of assets for estate tax purposes. So we don't want to have those unintended consequences. That $18,000 amount changes, just went up from 17 to 18, January 1. One of the things we discuss when giving gifts is tax basis. The recipient is going to take the tax basis of the donor whenever the gift is given. That may be important if it's a large gift and if the tax basis is low. If the recipient of the gift turns around and sells it, they're going to have a substantial capital gain issue at that point. We have, let's see, could be some Medicaid issues also. So this is a probably topic in and of itself, but we are not talking about any dollar threshold when it comes to Medicaid. So there's 18,000 out the window. If you give a gift of any amount to any individual and you turn around and you need to apply for Medicaid or things like long-term care, that application process is going to ask you, have you given any gifts to anyone in the last 60 months or 5 years? If the answer to that is yes, the value of the gift that you've given creates an ineligibility in that amount. So that ineligibility has to be made up before you would qualify for Medicaid. So that's an important discussion also. And the last kind of topic here that we wrap into estate planning at our office, at least, is powers of attorney. We think, so everything we've just talked about is what's going to happen after I'm gone, after I'm deceased. These are documents, powers of attorney are documents that are going to help you while you're still alive. So these documents are going to nominate an agent to act on your behalf, to do things for you until you are deceased, and then you look to the will or the trust, what have you. There's two separate types of powers of attorney that we use. There's what's called a property power of attorney, and that document nominates an agent. They're going to act to transact business on your behalf. I say out of 1, convenience, or 2, necessity. So convenience would be, I'm out of the country. I need somebody to go sign this document for me to purchase this house. Agent, here's the power of attorney. Go do that for me. Necessity would be, I'm in a coma. I need to get my bills paid. I can't do that. Agent can take that document. They can go do what needs to be done to transact business. The other document is a healthcare power of attorney. And that is a document that does a few things, but mainly it nominates an agent to act to deal with medical professionals like doctors, hospitals, deals with medical records if the person is incapacitated and cannot make decisions for themselves. Wrapped up in that document is decisions about life-sustaining treatment. Do I want to be kept alive by artificial means? Do I not? If that time comes, who's going to make that decision if I don't? Those types of decisions are in there. We wrap this up in the discussion when we talk about estate planning, because just like a will, just a trust, just like any of those documents, you have to be competent to be able to sign a power of attorney document. Since you have to be competent to sign those wills, it's just as good a time to get these in place and make sure that if you become incapacitated, somebody's able to deal with your things, deal with your property, deal with your medical decisions. All too often, we've seen where that happens. Somebody calls and says, we need a power of attorney for such and such. I'm sorry, they're not able to sign it. So really the only recourse at that point is petitioning the court for guardianship, which is a lengthy and can be a burdensome process. Powers of attorney hope to avoid that process altogether, make things a little smoother for the loved ones that are trying to care for you. All right. So I guess in summary, sure, everyone's circumstances are different. We talk to each individual to make sure we know what their goals are, what they're trying to accomplish. Each estate plan that we do, we think needs to be tailored specifically by the attorney, by the client to meet their goals, meet their needs. As I discussed earlier, it's important to review these things. They are not set it and forget it deals. So we want to keep them current. We want to keep them up to date with as we move through life. We think it's a good plan to make our wishes known, put them in writing, make sure we're going to avoid confusion and feuding. Confusion and feuding in our business is expensive and it's very time consuming. And with an appropriate amount of time to do a little bit of planning, I think it can be avoided altogether, which is really beneficial to everybody involved, I think. So I think at that point, it was close to 30 minutes there. I think I stayed on schedule with what I said. So be happy to meet with anybody individual to discuss your situation in more detail. If you want to get in touch with us, our information's there on the screen again. You have email addresses from us, things like that. We will send a follow-up also after this. But I think at this point, we still got some time. Happy to answer questions. I can get you guys unmuted if I didn't allow you to do that yourselves, but I think I probably did. Have you wave your hand, or if you've submitted questions to Kate, she can let me know what those are. Thanks again for joining us today. Anybody have any questions? Looks like there's a question in the chat that says, is that $18,000 limit per year? Yes, that amount changes, like I said, but that's per year per person. So if you have, for example, I have 3 kids, I want to give them a gift. I'm going to give them $15,000 each. So those are all from having to file a gift tax return. If I'm giving each of them $15,000, as long as the total cumulative amount doesn't get over that. Can't give them $15,000 today and then give them $15,000 again next week. It's got to be under that 18 to avoid that requirement of the gift tax return. That's a good question, though. That's a strategy we use sometimes if people are wanting to give gifts to keep them out of their estate. They can do that on a yearly basis. And if somebody has 2, 3, 4, 5 kids, grandkids, spouses, things like that, you can get to some pretty significant amounts pretty quickly with those threshold numbers. Kate is not able to unmute herself. All right.
So I have a question. Can I write my own will?
You can in Illinois. So if you write your own will, what it's called is a holographic will. And in Illinois, at least, those are not enforceable just in and of themselves. There's some jurisdictions where they say, if you have put your own will in your own handwriting and signed it, that's good. That meets the requirements. In Illinois, they say no. They say that is not sufficient for admissibility, for enforceability, it still has to meet the requirements of a will in the state. So a will has to be in writing, which it would be, has to be signed, which assumedly it would be, but it also has to be witnessed by two independent witnesses. So they can't be people that are invested in the estate somehow as beneficiaries or related to that person in some way. And then those witnesses are testifying essentially when they're witnessing that they believe that the person who's signing the document is of sound mind, that they know what's going on. They know who their heirs at law are. They know who the people are that are getting their assets. They know what their assets are, that type of thing. So if the will doesn't meet those requirements in Illinois, it doesn't work. So when we're doing estate planning documents with people, we are ensuring that those requirements are met so we don't have any of those problems. That's a good question. Anybody else send any?
What is the average cost to set up?
Average cost to set up. So the answer to that is the ultimate lawyer answer. It depends. It depends a lot of things on complexity of the plan. Depends on, are we doing just a will-based plan versus a trust-based plan? I would say probably good rule of thumb would be setting up a will-based plan with powers of attorney and things like that would be around maybe $1,000. Trust-based plan, unless there was some estate tax issues there, maybe 3,000-4,000, something like that, all said. But it really depends on the complexity of what's happening. I am not a big advocate for complexity just for the sake of complexity. I think if we can do things in a simpler way and accomplish the goal, that's what we should be doing. That is not the mindset of everyone that I've ever seen, but that's my thought on it. We would know that before we did anything, though, certainly, once we know the circumstances. Try to be pretty transparent about that before we do work.
How long does the estate planning process take?
So depends. The process we follow, just as a baseline, is if somebody called, made an appointment, wanted to meet with us, to one of our attorneys to talk about estate planning, we have some technology that we've invested in, and we ask, here's some information we want, the information we talked about, like the inventory of assets, and we have some guides that guide people through getting that information compiled. As long as everyone's on top of what they're supposed to be doing, probably maybe a week later, we'd sit down and we would discuss those things, figure out what we want to do, what we want to draft, what that's going to cost, all of that, get that all sorted out. And once we have come up with the plan, then we would draft documents, send draft documents to review, ask questions, discuss the questions. It's usually a time where once you've seen what I've talked about today, you've seen the actual documentation, it brings up more questions than just me talking about it in a vacuum. So then we make sure that everything says what we want it to say, get an appointment scheduled to get those documents signed appropriately, get our witnesses lined up and things like that, and then send those documents with the client after they've got them signed and got them completed with any remaining tasks at that point. But I would say, all said, that would be 2 to 4 weeks, as long as everybody's on top of what they're doing. We can usually get that done, I would think, within a month. Sometimes it takes longer, sometimes it takes shorter, but it's probably a good rule of thumb.
Okay, we have another question. In what case would a living gift need to be documented and recorded?
The documentation of the living gift would be the gift tax return that was filed if the gift was over the threshold, that $18,000 threshold. And that would be what documents the gift. I guess if there's a gift of real estate, for instance, there would be a deed that would be recorded that would transfer the ownership from the owner to the person that they're giving the gift to. So that would be recorded in the recorder's office. That would be documentation, but I think that answers the question. Did I get that answered?
Is a separate will required for married spouses, or can a joint will be created?
Yes. Yes to both. You can do joint wills. I personally don't like them. I don't like them for a lot of reasons, but one of the main reasons I don't like joint wills is when you're doing a joint will, the will becomes irrevocable when the first person dies. And I don't like that scenario. When we're doing wills for married individuals, they will each have a separate document. Those documents, most of the time, are what we call reciprocal. So they're very similar. They may say, I want my spouse to have everything if I die first. And then if they're not alive, to my kids, for instance. And the other one may say the same thing, but it allows the survivor to adapt to their circumstances that a joint will would not let that happen. You can have a joint will. I've seen joint wills. Sometimes they work. Most of the time I haven't had good experiences with them. So we usually do two separate documents.
You mentioned you should look at changing your estate planning. Is it difficult to do that?
Minor changes are not real difficult anymore. Back in the old days, it used to be burdensome when people were using typewriters and things like that because you had to retype the whole document. But a lot of times for wills, attorneys would draft what's called codicils, which was basically an amendment to the will. And we don't do a lot of that anymore. We typically will just redo the document if there's changes to it and re-execute a new document, which would revoke the old document. With the advent of word processing and things, those minor changes are not a big deal anymore. Trusts, we usually still do amendments to trust if it's minor changes. If there's major changes, again, we'll just do a restatement of that trust, which restates the whole thing and re-execute a new one so that it's all together. I don't like a lot of codicils or a lot of amendments or things like that because I have a concern that some of those things get lost along the way because they're not attached to the main document. I would say minor changes, no. If there's major changes, it is what it is. It's not overly difficult to make changes. And as long as you're living, competent, all the things we talked about before, you're able to change any of those documents we talked about today, anytime, as many times as you want to. So none of it's set in stone, which is why looking at it and reviewing it is important and prudent.
Does the inventory of assets need to be? Everyone has all the extra stuff. Do those things need to be included?
Not necessarily when we're talking about planning. If we're talking about administering an estate, sometimes yes. But when we're talking about planning, unless there's specific assets that we're giving to specific people, we don't necessarily need to inventory them in the planning documents. So we don't need to inventory everything you own in the will, for instance. If you have a car that you want to go to a certain person, we're going to put that in there. We're going to say my Buick is going to go to such and such, but everyone does have this stuff. There's usually a catch-all in a will or a trust that the residue or the leftovers, if you will, is going to be going somewhere. So that kind of is a catch-all that catches all those things. Some of it may be important. I will give the caveat that some of that might be important if it has significant economic value. Like if it's a really expensive thing, we probably need to know that if we need to worry about it for estate tax. But other than that, let's lump that into household furnishings and furniture and things like that. Stuff.
What is better, a will or a trust?
Depends. I think it depends on a lot of things, but I think it depends on mainly what the client is trying to accomplish. So if the client comes in and they say, I do not want will to be probated when I die, I don't want my executor to have to deal with the probate process, trust is better because that's the only way you're going to avoid it. If somebody comes in and they say, I don't want to do a lot of work, I don't want to have to mess with this a lot, but I want to have a plan in place for what happens, then the will is going to be better for them. So it is client dependent. Some of the estate tax issues maybe force you one way or another. If you have some complex estate tax planning you need to do, you're probably going to be in the category where a trust makes a lot more sense just because of the way that it works ultimately. But I think that's one of those things that's just very, very client specific.
We good for one more question?
Sure.
Okay. I always thought trusts were just the wealthy people. If I have a basic house, car, 401k, do I need a trust?
I think that goes back to the question that was just posed about which one's better. It may be better for that individual to have a trust if they come in and they say, I don't want probate. I don't want people that know about what's going on in my life. I want it to be private. I want it to be kept away from public knowledge, that type of things. Then a trust is going to be the way to do that, regardless of what it is that they own. If that's not an issue, they may be able to get away with it without a trust, but there's still some planning that needs to be done to make sure that you're not going to have to probate that will. And you may be able to do that in that circumstances without a trust, with maybe beneficiary designations, transfer on death designations, changing ownership, that type of thing. So it may be possible without trusts, but I wouldn't rule it out just because of the asset ownership. I think that's a prevailing thought is I don't have a lot, so I don't need a trust, or I don't need to plan for the inevitable. And I don't know that there's necessarily a monetary threshold on that. I think even if you owned nothing and you had minor children, there's some estate planning that you need to do to make sure that they're taken care of when you're gone. But that's all real client specific, I think.
We got one more here. What is probate?
Probate is the name of the court process of validating a will, having the executor appointed. We call it a lot of different things. So we call it estate administration. It is mostly not court supervised anymore, but it is what happens to the will and the process that the executor and the will go through to get assets transferred to beneficiaries. Actually wrote a book about it. Can't remember what I called the book. State Administration Handbook. Can send you a link to that. But that's what it is. It's the court process that we go through when somebody dies and we need to probate the will. There used to be a probate division in some courthouses, but that's just a case heading anymore.
That's all the questions.
All right. If anybody thinks of any others, you know how to get in touch with us now. Be happy to discuss those with you. Appreciate everybody joining us. Hope to talk to you all soon.